around and hanging out with me. Again, my goal here is to educate and to liberate, including liberate myself, free myself from the foolishness that goes on in trying to convince people what the criminal justice system is. A kind of foolishness that I went through on my own, trying to be an aspiring criminal trial attorney when I was in law school, when all of my professors were telling me, get the money, leave the idealism alone. Last week I said something and I want to follow up on, because if you're kind enough to shout someone out and say they did good, sometimes you have to point it out when they're not doing so good. In the city of Baltimore, I shouted out the mayor because she had a candlelight vigil for the young boy from Morgan State and the many bodies that had dropped. I think in the last video I said it was 244. I think he was 344, 344th body, and that was going into the new year. So she had a candlelight vigil. But now here you are in the city of Baltimore and the kids don't have heat in their schools, and you can see me with a sweater on in the studios. That's my protest for the kids. I don't care how hot or how cold it is in here, I'm wearing this sweater in honor of those kids who don't have heat in their schools. And we're wondering why it is that they're not functioning on the level that other kids in other schools are functioning, because they don't have the resources, they don't have the backing, they don't have the support. They have the drive, they have the intelligence, they have the creativity. They just don't have the resources that other schools and other people seem to have. And what it does is it beats you down as a child. It beats you down to be able to say that nobody really cares about me. So, Madam Mayor, please get the caring, for lack of a better way to put it. I also want to shout out a little article that I read from a young lady who's a teacher here in Baltimore City. Valencia, I believe her name is Valencia Clay, and she talked about the library cards, kids not having access to reading materials because they owe debts to the library. And one of my colleagues and I had a discussion, and she pointed out that parents need to be a little bit more accountable. Matter of fact, a lot more accountable. But you know what? All of us have to be accountable. I would love to see them waive the fees for these kids, to be able to allow them to read, but I would also love to see someone make everyone accountable in making sure that these kids are educated and educated properly. So therein lies your Raw Law Project. I am hoping that we can get you all educated properly. So let's get to work here. Now you see I got my pencil, I got my pad. Yeah, for those of you who don't think I read, I write too, I read, all right? I got my book too. So everybody who has their book, raise their hand. Very good, that's what I wanted to see. Now, let me just do a quick overview, because this case is dedicated, this class is dedicated to Erica Gardner. Erica Gardner is the daughter of Eric Gardner, a young man who was choked to death in the infamous chokehold in New York, in Staten Island. The 11 I Can't Breathe wasn't enough to get the police off his back, and they just really choked him to death on national television in front of the world. She never really got the justice that she was seeking for her father, and she died just recently at the age of 27. He died when she was 24. She became an activist, she became a hero, someone in the battle, in the fight, and unfortunately, sometimes that's what it takes, is for us to have these events that happen in our family for us to get active. I'm suggesting to you that each one of us pay a debt of respect to Eric Gardner and to Erica Gardner by not waiting until it's our child or our dad or our daughter or our sister who's choked to death, shot to death, locked up, in prison, disrespected, before we all begin to take a stand. That's, again, what the Raw Law Project is about, taking a stand. So let's do a little bit of an overview so you get an understanding as to where we're going today. The first thing that we talked about, I wanted to make sure everybody understood, was a concept called perception. Perception in the law, perception in the culture, perception in the criminal justice system. Perception meaning how you're viewed. There's three concepts within that. One, how you see yourself. Two, how others see you. And three, the truth. And so sometimes you see yourself as grander than you are or less than what you are. And sometimes other people see you as grander than you are and less than what you are. But somewhere in between all that is the truth. And all of that you have to fathom, and all that you have to navigate through when you're dealing through the criminal justice system. And if you don't walk into a criminal justice case, whether you be the lawyer who's trying to learn how to try a case or the seasoned lawyer who has tried every case, in the world and in the book, you still have to understand perception. If you're the victim of a crime and you're trying to get the prosecutor's attention so that they understand that you're the victim, it was your loved one who was murdered, it was your purse that was snatched, it was your bank or your store that was robbed, and they just seem aloof. You have to understand the perception that they have of you, and therefore you can make adaptations and adjustments to how you're going to move in dealing with the system because you understand perception. And what if you're the person charged? You're that person walking down the street. You're that person who's the victim of stop frisk. You're that person who the police run up on. You're that person who someone illegally or improperly accuses of a crime. You are going to be perceived a certain way, so you have to understand perception. Hopefully you'll go back and you review your notes on perception. When we left perception, we went to street encounters. There are basically 3 types of street encounters we talked about. The first one being a regular stop, meaning police walk up to you, police officer walks up to you, he says, hey, I'd like to speak with you. At that point, you're free to leave. The reason why I'm going through this overview is because I saw a video. It was a New York cop, stocky brother, explaining how you don't talk to the police. This is a cop saying don't talk to the police. I looked at the video, I watched it kind of closely. I agree with him. You don't talk to the police. I mean, it's just that simple. Because 9 times out of 10, they know something about what they consider to be the facts that you may not know, and you never know whether you're a suspect or whether or not somebody's just messing with you because they can, and which is really what stop frisk and what they call broken windows policing was all about. You can just get your numbers together by stopping any old ordinary black or brown or poor white person and get your numbers up just by arresting them, patting them down, doing whatever you want to do. But a stop means that you're free to leave, meaning that they say, hey, I want to talk to you. You ask them, am I free to leave? They say, yes, you're free to leave. Now, again, the officer said that in that video, so I'll go through all 3, and then I'll tell you really, in reality, what the whole goal is. The next one is the detention. Normally it's an investigation. It's called an investigative detention, which means it has to come with some articulable and reasonable suspicion that you're up to something, that the crime was being committed, and potentially you're the person who's committed the crime, or that a crime possibly could be committed. It's not based on a hunch, all right? Because when you get in a court of law and you say, hey, he stopped me for no reason, and the officer says, oh, I had a hunch. A hunch is not supposed to fly under the law. He has to have an articulable and reasonable suspicion for this stop, and at that point, you are not free to leave. You're not actually arrested, but you're not free to leave, and you know that by virtue of the order that he gives you. Stop, hold up, don't move. Those kind of things suggest that you're not free to leave. That's a detention, and it comes with certain legal frameworks. One of those is what's called a Terry stop, meaning they can pat you down for weapons, but only if they perceive a threat. Obviously, you know, that's a legal fiction. Believe me, they make it up as they go along on the street, which is why looking at the police officer's video gave me some concern. Because, I mean, as much as you want to say I got my rights, every one of you, go back to the Dred Scott decision. A black man has no right that a white man is bound to respect. And when it comes down to writing it down as to what happened, look, I wrote this in raw law. When I wrote it, was 15, I was maybe 18 years in practice. And I said this, and I'll stick to it. I haven't been in a courtroom more than 5 times where I thought the officer who did the arrest or who I was cross-examining told the truth, the whole truth, and nothing but the truth on the witness stand. And I can't even tell you how many times I've been to trial with police officers involved. All right, so I don't want to say all cops are bad. I'm just saying that the ones who testify do not tell the truth. All right, so we need to come to an understanding of that. So that's the reality of it. So even if you say, okay, yeah, he patted me down, he's going to write down, oh, he looked menacing, he looked scared, he looked like he was going to run, so I stopped him. I thought I saw a bulge in his pocket. It looked like a gun. It turned out to be a pack of gum with a marijuana blunt in it. Really? Come on. All right, but that Terry stop is only with a pat down for weapons. Then finally, there's an arrest. An arrest, you know you're not free to leave. At that point, they place you in what's commonly referred to as custody. They wouldn't. Smart officers don't read you your Miranda rights. I know you want. We discussed that, and the reason why they don't read you your Miranda rights, and I'll go over it again. They don't read you your Miranda rights because they're waiting for you to blurt something out. Because if you blurt it out, you volunteer information, it can be used against you. If they read you your Miranda rights and then you blurt something out, again, that's called a waiver. You have waived your right to Miranda, all right? But they won't tell you have the right to remain silent. I'm telling you have the right to remain silent. Keep your mouth shut. I don't care whether you're innocent or not. Keep your mouth shut. If they were going to arrest you, you can't talk your way out of it. So keep your mouth shut. Finally, last week we talked about what it is to be criminal-minded. And criminal-minded, in my humble opinion, means this. That person with a criminal mentality doesn't care about you. He doesn't care about mom. He doesn't care about dad. He doesn't care about the children. He doesn't care about anything but himself. His mentality is get mine. He does not care. I'm going to go back to that one because I'm going to give you a story. I'm representing a lady. She owns her son owns a condo in North. And she comes in because she's his mother. She's maybe about 60, maybe about 60, 65 years old. He's about 21. He's the baby, so you know how moms do with their baby boys. She used to come in every Tuesday and Friday to clean the place. Just so happens that the police raided on a Friday. He ain't there. He in the wind. I mean, he's out doing his thing. They kicked the door in based on a warrant. She's in there with her vacuum cleaning, her head tied, dusting and cleaning. And they lock her up because they find weight in his apartment. So they charge her because she's there. She's in proximity of it. And possession doesn't mean that you actually have it on you. It could mean that you have the ability to exercise dominion and control. That's called constructive possession, meaning it's within the range of area that you can get access to. So she's charged. Possession with intent, possession with intent within 1,000 foot, possession with intent within 500 public housing and a public park, etc. And she's facing 10 years in prison. She contacts me, asks me to represent her. They asked her, what do you want to do? She says, what do you mean, what do I want to do? I don't know anything about any drugs. I don't know anything like this. So I go to the prosecutor. I say, hey, she doesn't know anything about this. You look at your warrant. Your warrant says it's for the guy. The guy wasn't there. Your guys went too early. They should have scoped the place out, waited for him to be there. They say to me, see if you can get her to admit that she knew that the drugs were his, or give a statement saying that. I'm saying, I just told you she doesn't know anything about any drugs. Well, then we're going to prosecute her. They're prosecuting her under the premise, under the false premise, under the lack of understanding of what the criminal mind is like, that he's going to come forward to rescue his mother, and he never came forward. He let his mother stand trial. By the grace of Allah, she beat it, but he never came forward to rescue his mother. And frankly, we beat it because the warrant had his name on it. And you know I tried to ride that like a horse, you know. I made them take a picture of her when she took a mugshot. She had called from the apartment. I said, how are you dressed? When they were arrested and raiding it, she wanted to make a phone call. She knew at least to do that, so she called. I said, how are you dressed? She said, I have my apron on and my scarf around my head. I said, here's what you do. Have your neighbor or somebody take a picture of you in that outfit, so that the jury looking at this case, if it ever got that far, would know that she was there cleaning, not there hustling, you know. And so she beat it, but he never came forward. That's the criminal mind. So tonight, what are we talking about? At some point, you get arrested. There comes a time where you get charged. Now, listen to me closely. Charging is probably one of the key functions that you will never have any participation in. You get a piece of paper and it tells you what you're charged with. You don't draft the document. You don't have any input into the document. Nothing. So if you're on the lower level of the courts, and sometimes they call them superior courts, sometimes they call them district courts, etc., municipal courts. Municipal courts normally are those courts that are at a lower level where you're facing up to 1 year in jail and below. And district courts and superior courts are those courts where you can face anywhere from 0 to life in prison. Those are your trial level courts. These documents that they file are called complaints. If it's a federal court, it's called an information. These are preliminary reports. So when you hear someone file a complaint against you, expect to get a sheet outlining what the charges are. If it's a police officer filing this complaint against you, please don't take that complaint and throw it away. Some of my best cross-examinations have come from the original document that the police officer did, because they make mistakes. They're in a hurry to get their story told and, frankly, get their side of the story out as to why they arrested you, and they make a lot of mistakes in that complaint. And frankly, the complaint is sworn to, which means that when you cross-examine that officer, you get to say, did you swear to the truthfulness of that complaint? Yes. And in that particular complaint, did you charge the defendant with X, Y, or Z? Yes. I'll give you an example. We're on trial, and it's a drug case. And the issue was whether or not the defendant possessed the particular drugs in his car. The officer testified at trial that he saw the car speeding, etc., and he pulled the car over. When he issued the complaint and the summons said something like illegal parking. No summons for stopping. No summons for driving. Summons was for illegal parking. Now think about this. I told you a couple of weeks ago about something called search and seizure, meaning that you have the right to challenge in a preliminary motion, a motion before trial, whether or not the search of your vehicle was lawful. I had to convince the client to waive that hearing. The hearing could have resulted in the drugs that were found in the car being thrown out if we win. But my gut was telling me this judge is not going to throw 2 kilos of cocaine out of the car. It's not going to happen. I felt like we had a better shot with the credibility of the officer. Throughout the entire trial, the prosecutor and the judge fought me. Every time I asked a question about the complaint, they would say, we are not dealing with search and seizure, Mr. Bashir. You had an opportunity to file that motion, etc. I'm saying, I'm not dealing with search and seizure either, Judge. I was, but I sure enough said, I'm dealing with credibility. This is the credibility of the officer. This is a sworn statement from the officer that he's pulled this car over because of that he's approached this car because of an illegal park. He can't have it both ways. He can't say that the guy was driving and speeding on the witness stand under oath and then say, hey, he parked illegally under oath. Said, so I'm dealing with credibility. I was dealing with the suppression, but I wanted a jury to have to rule on that issue, and I used the issue of credibility by virtue of that complaint to attack his credibility. And believe me, I might have cross-examined this cat on his credibility for an hour just because of that error in that complaint. So do never throw that complaint away, because many of your lawyers will never read it. They'll look at it, boom, see what the charges are, see what the number is, what the language says, possession with intent, possession with intent to distribute, boom, they put it in the file, they wait for the indictment. You read it, because sometimes they put the wrong charge in it. They put the wrong charge in your summons, they put the wrong charge in your complaint. That could be the difference between going home or moving into another home. So be very, very cognizant of every piece of documentation that comes to you. This is what it is to outthink, to think like an attorney. You have to believe that everything that happens in this particular proceeding is important to you. Nobody thinks like that for our community. We think that, hey, young black kid, well, let me see if I can get him a good deal. Let me see if I can get the right number. And most of the defendants will be like, can you get me the right number? Like probation. They'll plead to anything to get probation. Oh gosh, they'll plead to anything to get probation. We're going to talk about pleas later on down the road. Once you have this information in the federal court or complaint in the municipal court, there's a process that has to go through before you can ever face trial. It's guaranteed to you allegedly by the Fifth Amendment to the United States Constitution. Anybody know what that is? I hear somebody over there. Okay, I'll tell you anyway. It's the right to have the matter presented to a grand jury. Now, this is why I'm talking about Erica Gardner. This is why this is dedicated to Erica Gardner and the respect that I have to hold for her. Let me just do a sidebar for a minute and talk to you about respect. I respect Erica Gardner because she stood in the place where her father couldn't stand. That she tried to rally a community and even a country towards something called justice. That takes a lot. It takes a lot to stand when nobody else will stand. It takes a lot to fight when nobody else is willing to fight. It takes a lot when other people think that they know better than you know about what justice looks like. And you have to respect that. But we're in a community now that our value system is so skewed. So our word for today is respect. And respect isn't something that you say, I I don't respect her because she don't respect me. You know, you heard that, right? And all of us have heard that. All of us work that line. But respect is about how you feel about you. You won't respect anything if you don't respect yourself. And the way you demonstrate the way you respect yourself, that you respect yourself, is through the things that you say and the things that you do. I'm at the library the other day, just doing some research. And there's two, maybe 16, 17-year-old boys sitting next to me at a computer. And every other word is an MF and an MF and an MF, and a B and a B and a B, and an S and an S and an S. And finally I turned to them, there's like 3 or 4 other brothers, maybe 30, 40, 45, and an elderly lady. And I turned to the brother and I said, hey, bro. And I always call them brothers, because that's a term of respect. My nigga is not a term of respect. I don't care what anybody says. You know, the B word is not a term of respect. And it says more about you than it does about the person you're calling my nigga or the B. It says much more about you than it says about them. In any event, I said to the brothers, I said, yeah, brothers, I mean, do you understand that you're in a public place and all these people hear your conversation, or at least part of it, and all you're hearing from you is profanity? It's like you have no respect for anybody at this table. Kid said to me, mind my effing business. And I said, you know what, you're right. I will mind my effing business. I said, because if you don't have the ability to respect yourself, I can't possibly expect you to respect me. I said, so you continue with whatever it is that you're doing. I said, but I looked over to the lady across. I said, ma'am, if they don't respect you, at least I do. I said, so I apologize for them in advance. You know that, in our community, we got some cats that'll take on a fight no matter what it is. All the older brothers now are like, yo, you two, out the library. You don't get out the library, we run you out. This brother was right. Because they stood with me on that one. You know, I was like the intellectual, they used to say. I was the bookworm, they used to say. But my brother Ismail, my brother Abu, damn, those are some thugs. So they was like, no, you don't do this, we do this, like that. I was like, okay, I'll talk a good game, but they do the other stuff. That always makes me laugh and always makes them laugh, because that's exactly how it played out. But respect is so, so, so important. And we have to change the value system. This culture teaches you that concept of survival of the fittest. That's not our culture. We don't survival of the fittest. We survive by helping each other. We're communal. We're not individualistic. We have adopted individualism because somebody has told us that Kobe Bryant made $20 million a year playing basketball. So we want $20 million a year. So we start thinking individually. We're not gonna make $20 million a year. If we make $20,000 a year, that's gravy for us. But if we made $20,000 a year and everybody made $20,000 a year and all of us pooled our resources together, we could live like we made $20 million a year. That's the part that we have to come to an understanding of. That because the culture says a particular way of thinking, we don't have to adopt it. The culture always disrespects us. And we have learned to disrespect us. By our tongues, by our hands, by our guns. And we respect everything about ourselves. We have to get back to respect. So tomorrow, when you see somebody, young black male, young black female, call a sister, call them brother, and feel good about the fact that they are in fact your brother or your sister. Now let me get back to Eric Gardner. An indictment is a matter that is presented to a grand jury. There are 3 or 4 things that happen at a grand jury. All of you have heard the expression that a prosecutor can indict a ham sandwich, right? And everybody always touts that. All your pundits, all your legal scholars, they always say, oh yeah, a prosecutor can indict a ham sandwich. And everybody's like says, ooh, a ham sandwich. Like, yeah, right. They can. But nobody seems to understand the point. The point is that the prosecutor is in control of that apparatus of the grand jury. And if they want an indictment, they will get an indictment. So when the Obama administration under Eric Holder and under, I forget the young lady's name, said that they could not find enough evidence to indict in the Eric Gardner case. What is it? What was the lady's name?
You talking about Sally Yates?
No, it wasn't Sally Yates. That was down here in D.C. I'm talking about up in New York, black woman.
In the district. I can't think of it.
Yeah. In any event, When they say that they can't indict, you have to go back and question that. Again, they can indict a ham sandwich. See, because what they're trying to say to you is they don't believe they can prove it at trial. But that has nothing to do with an indictment. An indictment is based on probable cause, meaning that they gather 23 people from the community in most jurisdictions. And they have to get a majority vote. So if 13, 12 vote for the indictment and 11 vote against it, you got an indictment. Just because the standard is so low, probable cause. That's the same standard that a police officer needs on the street to arrest you. More likely than not, he committed the crime. Then, once you get indicted, now the standard goes up to they have to prove the case beyond a reasonable doubt. But why is that important? Because, you see, they do it to us every day. Every day, people get indicted. They get indicted on murder, where they really the crime is manslaughter. They get indicted on possession with intent within 1,000 foot of a school, which has a mandatory term, when really the case is just a simple possession with intent, and the prosecutor really just wants to plead it out to possession or possession with intent. But they indict you at the higher number and then bargain at the number that they really want. Why can't they do that when it comes to police officers? Why can't they we just had a police officer plead out here, 5 of them plead out in Baltimore to racketeering charges or conspiracy charges. Why can't they do that when they shoot a young black man in the street? Well, don't worry, I'm going to tell you why. Once you are in the grand jury, when you have a grand jury proceeding, the grand jury proceeding is gathered for purposes of determining probable cause, enough evidence to charge, enough evidence to make the person have to stand over and come to court and say, not guilty, and then begin to go through the process like every other black person in the country would have to do. That's what a grand jury is supposed to do. It's an investigative body, and it comes back with that. The prosecutor is in control of it. The prosecutor subpoenas the witnesses. The prosecutor determines what evidence is going to be presented. Meaning the prosecutor could literally come in with hearsay information and have someone, a cop, read reports into the record. And a grand jury could say there's enough evidence there to indict. They don't have to bring the bloody shirt in. They don't have to bring in the pocketbook. They don't have to bring in the video. They just bring in enough evidence to get an indictment. And the way they word it may be the difference between whether or not you get indicted or whether or not you don't. They can indict a ham sandwich. If they come in and say that ham sandwich had 2 vials of cocaine on them and it's illegal to possess cocaine, and tell the ham sandwich to get him a lawyer. This is how simple it is. And if you recognize that, then you recognize one thing. That under 18 U.S.C., United States Code 18 U.S.C. 242, all right? The color of law statute is called. All of you look it up. It basically says that anyone acting under the color of law who violates the rights of any other person under any constitutional law or statute is subject to criminal penalties, including up to life imprisonment. So what happens when you grab somebody around their neck and you choke them to death while they're saying, I can't breathe? On something as suspicious as he's selling loose cigarettes on the street or he broke up a fight. And you know that he can't breathe. You know he's telling you, I can't breathe, I can't breathe, I can't breathe. And you still choke, and you still choke, and you still choke. And you do it as a police officer. Under color of law means that you're a cop. You're acting under the color of law. 2, you violated that person's rights, or you violated the law. A homicide is a violation of the law. The intentional killing of someone is a violation of the law. You now have 2 prongs that you have enough evidence that you can indict on. Eric Gardner's case. You have 2 prongs because Mike Brown was shot in the head and he was shot, 4 times. You have enough evidence that you can indict on. Tamir Rice was shot within 3 seconds, 4 seconds of the cop arriving on the scene with a toy gun, 12-year-old. A gun, if it were me and you, is listed as one of those things that has you, when you use it, you have the intent to kill. So if you're looking for an intent component, if someone is arguing with you that there's an intent component needed, the gun in and of itself gives you at least the presumption for purposes of you gaining the indictment. Remember what I'm telling you. This is what's going on in your community. And what's happening? What's happening in your community? Over and over and over and over again, Someone is shot, someone is killed under the color of law, and nobody gets indicted because the United States Attorney or the state's attorney said, we don't have enough evidence to prove the case. The minute you hear that, you know that they're lying. What they're doing is switching the narrative, switching the burden of proof because you don't understand it. They don't need enough evidence to prove them guilty beyond a reasonable doubt to get them indicted. They just need probable cause. And even though they have a mandate to seek justice, letting the process play out and not making the decision in your office as to whether or not you're going to indict is that seeking justice. Let the process play out. Let him get a lawyer. Let him get someone out there to represent him. Let that person lean on you and persuade you by virtue of the evidence that he produces or she produces that says you didn't commit the crime. And then you can make an informed decision. But at some point, you have that indictment in your hand where you say, you, Officer so-and-so, are formally charged. The average layperson gets indicted over the whatever. You know, all you got to do is say, hey, he did it. Yeah, who did it? He did it. I did it. Yep, you sure can.
So, for the attorney, what if their position is, I don't think I can win this case, and I want my stats to look like I won more than I lost?
You're talking about when you're talking about the prosecutor?
The prosecutor, yeah. So if the prosecutor has, because they usually have some greater aspirations aside from that, and they want to be able to say, my record was this or that.
Absolutely. All of them run around and talk about how they never lost a homicide. Right. Like Nancy Grace used to be on court TV, used to say she never lost a homicide. That's because out of the 20 that she had, she only tried one. She might have played out 19, you know what I mean? Played them out to manslaughter or involuntary manslaughter. But here's what happens in that situation. Your prosecutor always has what's called prosecutorial discretion. They could dismiss at any time. You saw it in the Freddie Gray trial. At some point, Marilyn Mosby, recognizing that she could not get a judge to rule on the evidence that she had presented to the grand jury, and that she could not get, nobody was going to take a jury trial after that first one. Right. All of them were smart enough to know, I write it in the book, all cops are smart enough to know you never go to trial with a jury if you're a cop. You go in front of a judge because nobody can make the standard to the satisfaction of a judge. You might be able to get some jurors to persuade each other, but a judge is not going to go for that. All right, so she recognized that, and she did what? In her discretion, dismissed all the charges. You understand? So they always have that discretion. But the question is, how much pressure is on you as a defendant if you have that indictment in your hands? Look at the pressure that was brought to bear on these cops that were charged with racketeering, helping in the drug sales and everything at Towson from out of Baltimore. That was pressure on them. Look, bro, you facing potentially life in prison. And if the judge uses discretion in the sentencing guidelines, you might really get smoked. But let me see, maybe we can work some of this off, because if you're behind the scenes, I'm telling this cat, look, maybe my guy can go undercover for you. He's a cop, he knows his way around, blah, blah, blah. You reduce that time a little bit, and you got somebody on your team. But the prosecutor always has in their hand that ace. Prosecutorial discretion. Doesn't mess up any of their statistics for them to walk up to the mic and say, we realize that we can't prove this case beyond a reasonable doubt now, and so based on new evidence that we found, we're dismissing this case against Joe Jones, officer. So it's not a matter of their numbers, all right? They know, 9 times out of 10, they believe they're going to win when they go to trial. But you can't get to trial without an indictment, and you can't get a plea, or you can't get meaningful discussion without an indictment, all right? So what else do the prosecutor have at the grand jury? He has process. He can subpoena people and bring them in front of the grand jury. Now, if you're a defendant, they can't subpoena you and make you come in front of the grand jury so that you get a clear understanding. If you're the one charged, if you're the one under investigation, they can't make you come in front of the grand jury and testify against yourself. Again, that's the Fifth Amendment. All right? You have a right not to incriminate yourself. So they can't do that. But, you see, there's a tricky thing that happens with that. They will sometimes grant you what they consider to be immunity or use immunity. Now, I had it happen once, and I got it from, I used to be a big fan of this show called The Practice, all right? And in The Practice, John Larroquette played this gay guy who kills his gay lover, and he blames it on his other gay lover. He hints that, I can't believe that, I think his name was Angelo, I can't believe he would do something like that. And everybody hears that like, I'm going to say I did it. Everybody's all excited. Oh, no, no, no. So they offer him a deal. If you just get us Angelo, then we'll, we won't give him a lot of time. We'll just, at the 30s, no, I can't do that to Angelo. He's playing them. Until they sign that immunity agreement. And in the immunity agreement, he negotiates it himself. He doesn't even ask Bobby Donald. He says, yeah, I want it in it that anything that I tell you can't be used against me. This, that, and the third, blah, blah, blah. And it's full immunity. I want full immunity because I don't want to be charged as an accessory because I helped to move the body, anything like that. Okay, no, don't worry about it. You have full immunity. And he got up and said, yeah, I killed him. I stabbed him right in his heart. I'm glad I did. Now can I go home? He had the immunity. They couldn't use it against him. They couldn't even use if they started an investigation based on it, that would be using it against them. It was a dramatic way of putting it, but that's what immunity can grant you. And that's how you get your co-defendants sometime to come forward and give you up. They'll grant them immunity from the charge or grant them a deal. If they're not having a deal, they say, look, I want some immunity. I don't want to be prosecuted for this crime. And if they're smart, they get up there and start confessing to everything, That's when they have immunity. But that's the nature of it. But that's one way to get a defendant in front of the grand jury. Another way is a stupid lawyer. Like, for example, let's assume you're a world-famous boxer. Let's assume your name is like Mike Lisen, and you come to court because you're charged with aggravated sexual assault in, say, a place like Indiana or something like that. And you get a lawyer, and your boxing promoter recommends a lawyer who happens to be a tax attorney and not a criminal trial lawyer. And he says to you, you know what, Mike, if you're innocent, you should tell the people. One of the stupidest conversations you'll ever hear in the world. It's always these people who don't understand criminal justice who are always telling you, you ain't got nothing to hide, you should just tell them. They don't know that they have forgotten that anything you say can and will be used against you. Even the good stuff is going to be used against you. So Mike, in his haste to demonstrate that he didn't do anything wrong, goes to the grand jury. 75% of the questions that were used to attack his credibility at his trial came from directly his answers at the grand jury. There's nothing in a lawyer's mind better than having a statement from another witness that you can go over and over and over and over to where you know his words, his inflections, his cadence better than he knows it when he takes that witness stand. So any discrepancy, whether big or small, becomes a mountain if you're smart, if you're good. You take that little discrepancy and you ride it like a horse. And then there's the other thing. It's the other part of the grand jury process. And that is the stuff that they bring to the grand jury. Can you imagine? Geraldo is out there. Don Lemon is out there in Ferguson, Missouri. And they're sticking microphones in people's faces. What do you think about this? Well, you were with Mike Brown like 5 minutes ago in the store. And the kid is looking at his friend right there on the ground. Blood all over the place. He's crying. He's distraught. That was my friend. 5 minutes ago, he was with me. Now he's dead. And Don Lemon is sticking a mic in his face. And he says, well, what happened? He didn't do anything. The guy just shot him. He didn't do anything. Well, I heard he was in the store, so. We didn't do nothing in that store. There was nothing. He really means he didn't do anything to deserve getting shot. But when you get to the grand jury and they start reading that statement, when you start saying, well, we went in the store and maybe we bought some blunts and maybe we did. So wait a minute. The prosecutor's the one in control of this grand jury. He doesn't want to see the officer get indicted. So now he starts cross-examining that witness based on these emotional statements that he gave in the beginning as a way of defeating his credibility and being able to say that the witnesses that we brought to the grand jury, you heard it. Just go back and look at your Mike Brown tapes and of the whole proceeding. The witnesses that we brought for the grand jury were not credible, and so therefore we were unable to obtain an indictment by virtue of that. He was the one who made him incredible because he had the power. This is what you do in a grand jury. When you have